This is Duke University.
I co-direct the program in public law here at Duke Law School, and today we're going to have a review of important civil, that is to say non-criminal decisions from the previous U.S. Supreme Court term, the October 2009 term. Later in the month we're going to have a review of important criminal decisions, and then on the first Monday in October we're going to have a preview of important cases on the docket during the October 2010 term. I have with me today several of my colleagues, Kate Bartlett, who is an expert in employment discrimination, family law, gender in the law, Guy Charles, who has a wide-ranging interest in constitutional law, election law, race in the law, law and politics, and on the side he teaches civil procedure. I have with us as well Professor Jim Cox, who's an expert in corporate and securities law, a very well-known figure in those fields, both here at the law school and way beyond. And finally, Professor and Senior Associate Dean Paul Haagen, interested in contract law, antitrust law, law in sports, history of law in society. They're each going to speak about one or more important civil decisions from the last term. We are not going to try to cover everything mercifully. We'll begin with Professor Bartlett, and then we'll move to Professor Charles, Professor Cox, and Professor Haagen.
Okay, I'm going to talk first about a case called Christian Legal Society versus Martinez, and then if there's time after everyone else is gone, I'll come back to an employment law case. So CLS versus Martinez was a case filed by the Hastings, the local Hastings chapter of the Christian Legal Society when Hastings Law School refused to grant it status as a registered student organization for purposes of getting all of the benefits that student organizations can get in terms of financial assistance, use of the school's channels of communication, use of the school's name and logo, and so on. CLS was allowed to meet in the physical facilities and also post notices on a bulletin board, but they weren't able to use the other benefits of being a Hastings club. Hastings refused registered student organization status to the CLS based on a policy that it had prohibiting discrimination on the basis of a number of prohibited characteristics, including sexual orientation. It interpreted this policy to mean that any student had to be allowed to participate in, become a member of, and seek leadership organization in any student organization, regardless of that student's status or beliefs. This was called the all-comers policy. So everybody, any wanted to be one of these clubs, you had to allow anyone to participate in, become leaders of, and so on, regardless of their sex, race, et cetera, and including sexual orientation. CLS did not meet this criterion because it excluded, quote, unrepentant homosexuals as well as non-Christians from the group. I'm sorry to see this morning that both the CLS and Outlaw are having club meetings today, so we don't have, we may have members, but some of the members are drawn away by those events. Okay, so in what could have made a difference in the case, CLS chose to oppose the all-comers, chose to challenge the all-comers policy rather than the non-discrimination policy itself. And there is language in the decision about how CLS made the stipulation and the court was going to hold them to the stipulation. As such, then because the challenge was to the all-comers policy, the court concluded 5-4 that this was a neutral, content-free regulation and thus did not violate CLS's First Amendment rights. And the case was remanded to determine whether the policy, in fact, was fairly and evenly applied. So there is some question going forward whether schools that have something that don't have this all-comers articulation of an all-comers policy, but rather a non-discrimination policy based on these various factors, whether that is also content-free. That was not decided by the case, was sort of conspicuously set aside and kind of an interesting case which we can be sure that the national organization of CLS will want to pursue at other schools. This has been part of a larger campaign of the Christian Legal Society, and has approached a number of law schools who, until it got to Hastings, all kind of conceded the point that CLS was making, that there could be some religious matters of conscience and belief, and that they had, as an organization, the right to maintain the integrity of the organization around those beliefs. But Hastings didn't concede the point, and thus this litigation. One of the interesting things about the opinion is that the majority gives some recognition to the difficult spot that a law school is in, that both wants to afford groups their rights to share, to have beliefs and to act upon those. On the one hand, on the other hand, a law school commitment to non-discrimination. So the court was willing to allow some leeway to a law school to decide how it wanted to handle this potential conflict between those two goals. Okay, the case is not over. There's continuing. Hastings has filed its suit to say that it's not, or is on remand, is in the process of arguing that Hastings did not fairly apply the all-comers policy. So there will be another chapter.
Afternoon. So this afternoon I'll talk about Citizens United versus FEC. Citizens United challenged a federal campaign finance law that prohibited corporations and unions from using money from their general treasury to make independent expenditures. The statute in question, 2 U.S.C. Section 441B, said that corporations and unions can't use money from the general fund to, say, run an ad expressly supporting or opposing a federal candidate, say 30 days before a primary or 60 days before a general election. Now, corporations and unions can use money from what usually called a segregated fund, which is a separate fund dedicated for that purpose. They could use money from that, but they can't use money from their general treasury funds. In an opinion by Justice Kennedy, who was joined by the Chief Justice and Justices Thomas, Scalia, Alito, the court held that the prohibition was unconstitutional and in violation of the First Amendment. Now, Citizens United is a nonprofit corporation, and it receives most of its funds from individuals, though it receives a small amount of funds from for-profit corporations. In prior cases, the court had carved out an exception for nonprofit corporations, essentially saying that they weren't bound by this prohibition against using general treasury funds. But because Citizens United receives a small percentage, and now one could argue whether it was a de minimis percentage, but a fairly small percentage of its funds from for-profit corporations, it felt and was was regulated to have been part of the prohibition against using corporate general treasury funds. Citizens United had produced a movie or documentary entitled Hillary the Movie, and the subject of the documentary, as you can guess from its title, was the then senator from New York, Hillary Clinton, who was running for president. And the documentary was very critical of Ms. Clinton, and Citizens United wanted to run ads on television to promote the documentary. And it was worried that if it ran the ads promoting the documentary, the ads and the documentary would be viewed as a violation against corporations using general treasury funds to run an ad in support or against a federal candidate. Now, the Supreme Court rejected the argument, the statutory argument, that the documentary did not come within the ambit of the statute on the ground that the documentary could be held as what are called electioneering communication. So one argument that was advanced is, look, this is a documentary, it is not an ad, and the court essentially said, look, this is more like an hour-long or long movie that it was more like an ad that was fairly long, basically saying, we don't like Hillary Clinton, don't vote for her. The court also rejected what, at least in my view, would have been the most promising basis for deciding the case, which is that since Citizens United is a nonprofit corporation, and since it receives minimal funds from for-profit corporations, it should have the benefit of the court's prior opinions, essentially saying that nonprofit corporations aren't bound by 441B. And the court, for many reasons, one including the argument that doing a separate PAC was too much work, and therefore a prohibition on speech, the court rejected that argument and declined and said there's no basis for distinguishing its prior cases, that this is really a ban on speech. So the court avoided a number of possibilities, especially on statutory grounds, and accepted a challenge to the statute on facial grounds, on the ground that the statute was unconstitutional. Quickly turning to the First Amendment challenge, Kennedy's departing premise was that 441B, the statute in question, is an absolute ban on corporate speech and that it prevents a corporation from speaking by making expenditures on behalf or against particular candidates. And he argued that this prohibition was also viewpoint discrimination, that you're singling out corporations and their viewpoints on the grounds that perhaps their views are different from those of other citizens, was viewpoint discrimination, which is inconsistent with the First Amendment. He went on to note that the First Amendment protections apply to corporations and that it applies in the context of political speech. And the court said that the only basis upon which you can limit speech in this context was to prevent corruption. And since this is an independent expenditure, then you really aren't, the government isn't trying to prevent corruption, and therefore the government doesn't have a basis for limiting speech. Now, in the process of all of this, the court also had to overrule one of its prior precedents, in particular, specifically a case called Austin versus Michigan Chamber of Commerce, which had upheld an expenditure restriction on the ground that corporate speech distorts speech in a democracy. And the court said that this anti-distortion rationale is not or is no longer a compelling governmental interest. Now, this opinion by Kennedy comes across as both a fairly strong free speech and strong corporate speech and union speech case, which of course you may remember drew fairly strong reactions from the President of the United States, occasioned by his State of the Union address. Fundamentally, in my view, the opinion is quite clear that the court wanted to reach the constitutional question. It wanted a confrontation with Congress on this issue, and it wanted to establish once and for all, from its perspective, that bans on corporate political expenditures are firmly unconstitutional under the First Amendment. Citizens United presented that opportunity, and the court reached out and took it and ran with it. Just some quick wrap-ups. Chief Justice Roberts wrote a concurring opinion joined by Justice Alito to argue that why stare decisis in this case was not a sufficient bar to prevent the court from overruling its prior precedent. So he felt the need already to anticipate this objection and to deal with it. Justice Scalia wrote a concurring opinion to address a point raised by Justice Stevens questioning their commitment to originalism. So Justice Stevens says, you think you're originalists, but you're really not, and if you were, you would understand the scope of the First Amendment. So Justice Scalia felt that he had to respond, and he did. And Justice Stevens took the majority to task in his dissenting opinion, which was joined by the other liberals on the court, took the majority to task for not making a distinction between human and corporate speakers, for breaking with stare decisis, for reaching broadly to address the constitutional question, for accepting this as a facial challenge, and for not understanding the proper scope of the First Amendment. What you have in this opinion are clearly two different views of the First Amendment. One offered by the majority that is fairly formalistic, another offered by the dissent that is much more nuanced. Two different views of the role of corporations. One offered by the majority in which corporations really are not very different from individuals. In fact, both Scalia and in the majority opinion, you see this idea that, well, corporations are just people getting together to form an entity. So what you really are protecting is individual speech and not corporate speech. Two different views of campaign finance regulation. Clearly, one view, the dissent, that views campaign finance regulation as important and necessary in a democracy, and another view, the majority, that sees campaign finance regulation as being in fairly strong tension with the First Amendment and is cabining and limiting the reach and scope of campaign finance regulation. My guess is what you'll see from here on out, and you've already started seeing it, are groups that are anti-campaign finance regulation, challenging and getting the scope of campaign finance regulation limited to the contours that the court is projecting, which is, if it's not about corruption, then it's probably unconstitutional.
Thank you very much, Professor Charles. Professor Cox.
Well, in the 10 minutes I have, I'm going to try and talk about three cases, but I'm going to spend most of my time on the one that's going to have the greatest impact upon society and you directly, and that's Jones v. Harris. It deals with an industry that we would think is fairly arcane, but for most of us, but it really isn't. It's the mutual fund industry that regulated something called the Investment Company Act in 1940. This industry has under management for individuals over $9 trillion. That's about 65% of last year's GDP. The mutual funds are a corporation. The assets of the corporation are as a portfolio of securities, and that portfolio of securities is managed by another corporation called an advisor. The Investment Company Act has long said that investment companies have to have a minimum of 40% of their directors being independent. Congress found that the fees were way out of line, and in 1975 amended the act to say that the investment advisory contract had to be reviewed annually and would be subject to a fiduciary standard. Nobody knows what that is, and that's what the litigation was all about. Now, what I find particularly intriguing about this is who brings these cases. And so some of us here at the law school know the law firm that was driving these cases. This is a firm that started off initially bringing plaintiff's class action firm, bringing asbestos claims, and then hitting the jackpot on being one of the firms that got literally hundreds of millions of dollars in attorney's fees in the tobacco litigation. They were all too young. Their wives and husbands didn't want them hanging around the house, so they didn't give up on the idea of practicing law. And so they just decided, they looked around for an industry they thought was pretty sloppy and fat, and the answer was the mutual fund industry, and started filing literally scores of cases attacking the fee arrangement and getting lots and lots of settlements. One of their major arguments against the fees is that when you buy into a mutual fund, you're paying something like 0.5% to 0.75% on the assets under management. But when a pension fund or some other institution negotiates with the same advisor for the same fund, the fees are substantially lower. So the question is, in identifying whether the fees are appropriate, can you look at what's truly arm's length negotiations, that is, between the mutual fund and the institution who's negotiating aggressively, a labor fund or something like that. And that's the argument they've been pushing. This goes up to the Seventh Circuit, where Frank Easterbrook, in a case that was argued by our own Ernie Young, albeit unsuccessfully, Frank Easterbrook says, listen, the investment company says you have a minimum of 40% of your directors are independent. That's what Congress intended to be the first and only line of defense in evaluating whether fees are excessive. And if people don't like the fees, they can move down the street and select another fund because this is a dynamic market. So essentially it threw the case out, and that's what it goes up to the Supreme Court on question about what are the heuristics for determining whether a fee is excessive or not. And the court's answer is the following. One, Judge Easterbrook was wrong, okay? Two, any reasonable approach to determining fees is open, okay? So we don't know what the answer is, except what Frank Easterbrook did was not right, and it opens everything up. It's one of these cases where everybody's declaring victory. The plaintiffs say, aha, we're going to make a lot of money here, and the defense lawyer said, we're going to win every one of these darn cases going forward. We don't really know from that, but I think that the answer is going to be down the fact that any approach, including what occurs in arm's length negotiations. Let me just take about 30 seconds to tell you about these independent directors. These independent directors come into a meeting. I've been an independent director of these funds. And they come in these meetings, and they sit on somewhere between 30 and 90 different funds, and they meet for a morning, approving the fees for all these 30 or 90 funds, and they get a small amount of money for each fund that they serve on, like $11,000 for every fund. But if you're on 90 of those funds, you're talking about real money, right? Mm-hmm. So my question to you is, how independent are these people, right? And so that's always in the background of this thing. The court punts on that. And so this is ongoing, and it's something that if you're going to the litigation area, you will encounter. Now, the other litigation case that came up was Morrison against Australian National Bank. This goes to the question about the scope of the anti-fraud provision of the securities laws. The anti-fraud provision talks about fraud in connection with interstate commerce. Interstate commerce is defined by the Act as including events that occur across territorial lines, okay? So the issues in the Australian National Bank case was you had an American subsidiary that cooked its books, and then those numbers were incorporated into the financial statements released by an Australian bank. And so the plaintiffs in this class action were Australians, okay, who bought on the Australian Sydney Stock Exchange, okay, stock in an Australian company, the so-called F-cubed case. So you had plaintiffs were Australians. They're not Americans, although they speak a variety of English. They bought on a foreign market in a foreign firm. And the question is, does securities laws apply there? Now, Henry Friendly, who's one of my great heroes, wrote a lot of law on the question about what we do with these extraterritorial cases, all of which the court ignored, okay? And the court goes on the question of not normal bases of jurisdiction of the suit, but said that it was never Congress's intent to protect foreign investors when buying these securities, and dismissed the case. And you may say, well, that's good. Why the hell do we want to make the American court system available to these people who speak with a strange accent, right? And they bought this stuff abroad. Let them sue in their own damn court, right? The problem with that is it overlooks a long line of Supreme Court precedent that says that enforcement of the securities laws is important, and that important part of that enforcement comes out of private actions. And also the analogy that Henry Friendly used, that a local country does have an interest when a person stands in this country and fires a shot across the border and strikes somebody across in another country, that we don't want to become a Barbary Coast for fraud, and so private actions are important. Well, the epilogue to this is that Dodd-Frank, this bill that's 2,300 pages long, this decision is the next to the last day of the court when they hand down the Australian bank case. Dodd-Frank gets passed in July. There were never any hearings on it. Congress is going to fix it, okay? Congress fixes it. No, they didn't. Many of us were saying, no, they didn't decide this on jurisdiction, okay? They decided this on the substance. So Congress went and amended the jurisdictional provision of the Exchange Act to say that, at least in SEC actions, that there would be jurisdiction to handle these cases. The problem is that it doesn't address what happened in the case itself, which is substance. And in 2 minutes, okay?
You've got time.
You sure?
I am.
Okay, in an hour and a half.
Just no more sexist jokes.
The next case is the free enterprise case. Now, who would ever care about bringing a case to say that an agency that was created to regulate the auditors of public companies, okay, that agency was unconstitutional, okay? And this case is brought by a group called the Free Enterprise Institute, who's probably never met an auditor in their life, okay? But what their real concern was that the fact that Sarbanes-Oxley did not include a severability clause. So Sarbanes-Oxley is a collage of various enactments, and a keystone part of that was regulating the auditing profession, but it covers all kinds of other things as well, and it had no severability provision. And so the idea is that if you could strike down one provision of Sarbanes-Oxley, then the whole act implodes for the lack of a severability. So that's what was at risk in the Free Enterprise Institute case against PCAOB. Short order, what the court said was that the provision that was challenged in this litigation is invalid. That is to say that the members who direct the PCAOB can only be removed for cause, and then they can only be removed by commissioners of the SEC who can only be removed for cause. And this double insulation from the executive arm of the government violated the appointments clause of the Constitution. They struck that down. But they made great effort to say it's only this provision. And in fact, what's wonderful about the free enterprise case is in the process of justifying other aspects of the creation of the PCAOB was I see as a strong, warm, open embrace of the vision of the New Deal Congress as to the role of independent regulatory agencies. So there's a huge amount of language, rhetoric, and reasoning, and even holdings in the case to support regulatory action as it was envisioned in the magic days of FDR's first 100 days. Okay.
Thank you, Professor Cox.
Okay, you've heard deep questions about participation in society, the nature of elections, the organization and regulation of the economy, and now I'm going to talk about logos on hats. American Needle versus the NFL. It's an antitrust case that was either the last or one of the last opinions written by Mr. Justice Stevens. The specific question presented in the case was whether the National Football League and its member teams were a single entity incapable of violating Section 1 of the Sherman Act, at least in that aspect of their relations dealing with the licensing of intellectual property in connection with the manufacture and sale of apparel. This is a multi-billion-dollar industry, and it's been estimated that 10% of the value of all clothing purchases in the United States carry some sort of sports-related logo. Now, for those of you who have neither committed Section 1 of the Sherman Act to memory or who do not carry it conveniently with you, it provides that every contract combination in the form of a trust or otherwise, or conspiracy and restraint of trade or commerce among the several states or with foreign nations is declared to be illegal. The single entity defense is the common sense proposition that it is impossible to conspire with oneself. In American Needle, the Supreme Court held that the NFL was not a single entity. It was not a controversial opinion, either within the court itself, it was one of those increasingly rare 9-0 decisions, or in the scholarly community. The majority of antitrust scholars, including our own Professor Richman, either urged this result before the case was argued or applauded it afterward. The general consensus is that the opinion did not break new ground in antitrust, but rather reaffirmed 25 years of fairly consistent analysis. The case, moreover, did not decide the merits, only the issue of the single entity defense in this case. So this may be the classic case that did not bark. I'm not only dealing just with hats, I'm dealing with something that didn't appear to make any change. Well, what was at stake in this case? Professional sports leagues are a peculiar kind of economic activity. In their nature, they require very extensive forms of cooperation over such matters as the rules of competition and scheduling, and the cooperation is essential to the production of the product which is competition. Competition is thought to be enhanced if the parties to the competition have acceptably equal resources or access to resources, for example, the same number of players on each team, and in broad concept, this is the idea of the level playing field. From very early on in the organization of professional sports, there has been both doubt and tension about how the need for this cooperation relates to the general American economic policy in favor of competition enacted in the antitrust laws. In the first case that dealt with the problem, Federal Baseball Club versus the National League, the Supreme Court held that baseball was not commerce within the meaning of the antitrust laws, the so-called baseball exemption, but the court then proceeded to decline to extend that exemption to any other professional sport. Each of the other sports has, therefore, either turned to Congress for specific types of protection, for example, the Sports Broadcasting Act, which allowed the merger of the American Football League and the National Football League, or has sought to bring to protect its activities under the non-statutory labor exception by enshrining its anti-competitive behavior in a collective bargaining agreement. This is one of the reasons that American professional sports is one of the places in which management actively has encouraged the creation of unions. They also have protected their activities under the so-called rule of reason, which permits restraint of trade where the effects are more pro-competitive than anti-competitive. For a variety of reasons, this legal situation, is highly unsatisfactory to the owners of professional teams and the management of the leagues, and they have sought for years some sort of general protection for their cooperative, restrictive arrangements. The NFL in particular, and in particular its then chief outside counsel from Covington and Burling, Gary Roberts, who is now the dean at IUPU, whatever. What? Okay. Law school. And they seized on the Supreme Court's decision in Copperwell Corporation versus Independence Tube Corporation immediately after its announcement in 1984. The NFL has consistently urged the theory that it is a single entity ever since. The lower federal courts prior to American Needle had just as consistently rejected the claim, and despite this, the defeats never diminished the NFL or Dean Roberts' enthusiasm for the defense. Why? Because if the courts had recognized the defense here, it would have created a template for structuring professional leagues so as to avoid Section 1 antitrust scrutiny. Now, American Needle itself, the case itself, involved a challenge by an apparel manufacturer to the decision by the National Football League Properties, the NFLP, an entity created by the NFL and its member teams in 1963, to grant an exclusive license to Reebok International to manufacture and sell clothing bearing the logo of the NFL and or its member teams. Between 1963 and 2000, the NFLP had granted non-exclusive licenses to a variety of companies, including American Needle. But in 2000, the teams voted to authorize the NFLP to grant an exclusive license, which it did, and caused it to refuse to renew the licenses of all of the other entities, to all of the other entities like American Needle that had formerly made hats. The district court granted summary judgment for the NFL on the Sherman 1 claim, and the Court of Appeals affirmed asking what it referred to as the Zen riddle, who wins when a football team plays itself? Now, what was ultimately at stake beyond hats and jackets is not entirely certain, and there is considerable scholarly debate about how far this would have gone had the court recognized the defense here, but certainly the unions believed that it would have effectively destroyed their ability to have leverage in labor negotiations if they did not have the threat to disband the union and throw themselves entirely on the antitrust claims. But in any case, the Supreme Court declined to engage in the Zen metaphysical speculation and held that whether an entity is single or not turns on substance, not form, and on the question, does the agreement deprive the marketplace of independent centers of decision-making? The inquiry Justice Stevens wrote is one of competitive reality, not of formal categories of legal entities. So, as a result of this case, the NFL is back where it was, and the edges of permissible cooperative behavior are back in the uncertain world of the rule of reason.
Great. Thank you very much, Professor Haagen. We have a good amount of time for questions and discussion, and I thought maybe I would get things started by inviting each of the panelists to reflect on whether there are any broader implications or lessons one could draw from these decisions. Admittedly, it's a small sample size, but do they in some way provide a window into the early Roberts Court and what kind of court it is? For example, American Needle is 9-0, right? Professor Richmond earlier in the week used it as an illustration of the success Justice Stevens had to a large extent of bringing the rest of the justices along to his view of antitrust law. Doesn't seem to be a ton of division. There. Free enterprise, the last case Professor Cox discussed. This was a separation of powers fight in which you had what appeared to be a conservative liberal split. You had Chief Justice Roberts and Scalia, Thomas, Alito on one side, joined by Kennedy, and then you had the so-called liberals on the other, right? Stevens, Ginsburg, Breyer, Sotomayor, right? The majority is talking about accountability to the president. Right? The dissent is talking about the importance of independent agencies and the functions they perform. Citizens United, another 5-4 ideological split with Kennedy joining the conservatives. Christian Legal Society, a 5-4 ideological split, but in this case, in a very careful majority opinion, Kennedy joins the liberals, right? Comes out the other way. So what do we know from these cases or others about the early Roberts Court and what kind of court it is and when it's likely to divide in particular ways?
Kennedy's very important.
Kennedy's very important, right? That's why it's often called the Kennedy Court. That is certainly true.
Well, yeah, I would just add one thing, defer to the public law scholars on the question about how to read the free enterprise case. I will say the following, that the result in the Australian National Bank case, the F-cubed case involving the Australian investors in an Australian entity, is consistent with a long line of cases under that go back in the early days of the Roberts Court and being very hostile and rejective of any notions of private actions under the federal securities laws. And so the thought that they would find an opportunity to say that we're just going to cut out this whole line of cases is consistent with a long line of other cases. So that didn't catch anybody by surprise, I think. On the Jones v. Harris case, I don't think they had that, even though that was private litigation. Congress had expressly provided a private right of action for challenging fees, and so they couldn't very well ignore that. What they did ignore was providing any clarity going forward as to what a fiduciary duty means in this context. So and on the free enterprise case, again, I think it really was something of a jump ball, and I think most of us were very surprised about the outcome about that, because there are lots of ways that this case could have gone the other way, and it remains something of a mystery to me about where it did turn out.
In some respects, I'd say the Roberts Court is, so far, is a very confident court. There are few issues that it refuses to tackle. There are few legislative, whether it's statutory moves that it won't make. There are few constitutional questions that it doesn't have any opinions on. And in many respects, it's not a modest court. And I don't mean that pejoratively. That is, I think it is developing a theme that does depend in part on getting Justice Kennedy to cooperate. But there are ways in which I think the sharper the issues are presented in some respects, the bolder the court seems. And here, I think, in Citizens United, I think the issue is fairly sharply presented with a fairly strong set of choices, and it was not surprising to see the court react in a fairly strong and immodest way.
I just want to say, I think there are exceptions. I don't know, that there are some cases, and Citizens United seems to be one of them, which sort of has been held to stand for what the Roberts Court is all about. But both of one of the case I spoke about or the case I didn't speak about are both cases where the court could have decided more than it decided. So in the CLS versus Martinez case, the court could have decided what would happen if there was the clash between the non-discrimination and the First Amendment, direct confrontation, and kind of avoided that question. The other question, the case I didn't talk about, was a follow-on to the Ricci case from last year, where it looked as if the court was about to bury the disparate impact theory of Title VII, and they not only pulled back from that, but it was a 9-0 decision to have a very liberal, the most liberal possible application of the statute of limitations to preserve a disparate impact case. So, it's not a uniform, I wouldn't disagree with you necessarily in the headline cases, but it's not a uniform commitment to taking over as much as possible.
I hadn't said anything about the Citizens United case, but let me say that I think most corporate scholars, whether you're on the right or the left, felt that this was an opinion that was written by somebody who had just recently entered this planet, because they demonstrated, as they've demonstrated in lots of other areas, a lack of understanding about what goes on within a corporation, particularly a large corporation is going to be able to make the kind of contributions that we all fear will follow. Those of you who have yet to take a business associations class, you'll find that a lot of time spent on something called agency costs, and whether the problems that arise from the owners being very removed and disassociated from the executive wing. And as a consequence of that, to think that the corporation's interest gets spoken on contributions strikes many of us, whether you be a liberal or a conservative, as a misguided notion. That these, particularly in the range of political contributions, these are frequently decisions that are made by an executive, and the same thing with charitable contributions, which is another big area, that gets driven by the executive's heuristics, not heuristics that are guided by what's in the corporation's interest. And that's why the response you're seeing in lots of states is to modify their corporate codes to condition charitable contributions as well as political contributions on an allocation that gets approved by the shareholders. Much like what Warren Buffett, the oracle from Omaha, does with Berkshire Hathaway.
Would you
just take two possibilities with American Needle about what it shows. One is it may show that this was a case about hats and the court was not particularly interested, and that's why you get 9-0. The other is that it may be something where the court was explicitly unwilling to consider some of the practical problems involved in running a sports league and the costs that would be involved in trying to defend under the rule of reason. What was most centrally at stake were things like franchise movements and things like that. That's what the league's really concerned about. And the court started with a general theoretical proposition about the way in which the economy ought to operate and really gave no attention to the NFL's arguments about what it needed to organize the activity. The reason I think it's 9-0 is that what would be usually thought to be the left of the court was not particularly interested in allowing them to organize their activities in such a way that damaged labor, cities, and other kinds of entities.
Mm-hmm. Did you want?
I think you should take a crack at that question.
Well, one way to think of it is this way. I mean, Chief Justice Roberts has said now famously, not just his analogy between Supreme Court justices and baseball umpires, right? Justices are like umpires, it's a very limited role. But he also said at a graduation address at Georgetown Law School, he said, if it's not necessary to decide more, it's necessary not to decide more. And scholars have called this a commitment to judicial minimalism, right? The opposite of a confident, right, reaching out sort of court, but decide cases narrowly, right? Decide cases shallowly, decide what has to be decided, and leave lots of other things undecided. This, among other potential virtues, brings other people on board inside the court and outside the court, gathers consensus, right? And the question is, when does this court feel inclined to decide cases that way, and when does it feel inclined to reach out and decide more than it has to? So in Citizens United, Chief Justice Roberts is confronted with this statement that he made, right? And he writes a defensive concurrence explaining why, in fact, in this case, it is necessary to decide more, right? I mean, part of the story is that the court set the case for re-argument after they passed on the opportunity to decide it narrowly in any number of ways, and then asked the parties to brief whether two important decisions, including the Austin case, should be overruled. So there's something about how important the substantive constitutional values are of the particular justices, what kinds of controversies are likely to split the court in ways that we identify as part of the so-called culture war, or right, these views about personal and collective identity, like religion, like campaign finance, like race, like abortion, like the death penalty, right now, like guns, certainly homosexuality. There are certain kinds of issues that are going to predictably fracture the court into these camps, and Justice Kennedy, right, who is President Reagan's third choice, right, goes one way, goes the other way, depending upon the issue, right? I don't think if Judge Bork had been put on the court, we would have had the same problems with predictability, right? So I think there are certain kinds of issues that fracture the court in the way the country is fractured, other kinds of issues in which there's more of a desire for consensus, there's more of an agreement on the values that are at stake. So, okay, let's hear from you folks. We've got 15 minutes. Questions? Comments? Yes.
For Professor Charles or any of the other professors who want to address it, one of the criticisms of Citizens United is that at the federal level, this isn't really going to be that big of a deal because there's so many giant competitors. But in state elections and local elections, that this could really have a huge impact. Excuse me. Considering it costs so very little to influence an election in perhaps a rural area or a local at a local level. So I was wondering if you saw that as one of the damages done by Citizens United, or if you think that that's kind of an exaggerated claim.
No, I mean, partly we're waiting to see how Citizens United shake out. Just to jump ahead a little bit and give you a sense, you've all seen the controversy that Target in particular got into recently when it weighed into a campaign, perhaps inadvertently. It was a contribution to an entity which then was linked to a particular candidate, a donation to an entity that was linked to a particular candidate. So and they're in a state context, right, a national corporation in a state context. So partly, I think we're waiting for it all to shake out, to see to what extent are we really worried about corporations in the state and local races in particular, because as you're saying, but also to what extent they may play a national corporations playing a role in localities, but also some of the other places that people have talked about are unions and the role that unions have traditionally and will continue to play both nationally and in respect to state and local races. So far, I think that the worry is that we're projecting out that the role that they will have a disparate or disproportionate impact with respect to corporations. But there might also be a lot of political process pushback, right? So you can imagine corporations looking at what Target is going through, even in a local context, and saying to themselves, you know what, I don't want to be the target of a national boycott campaign. So all of these things are worth thinking about.
Yes.
What about the criticism that some are making that Citizens United provides a constitutional springboard for the elimination of individual campaign contributions?
Individual campaign contributions, I think, is a lot harder, and campaign contributions from specific individuals, that's a lot harder because the corruption rationale is still in play with respect to individual contributions. Because what you're worried there is you're worried about the line where we say, okay, if I give $500,000 to a particular candidate, there is a pretty decent likelihood that that candidate will be beholden to me. Now, with respect to expenditures, what the court is saying is, if the corporation is making an independent expenditure, all right, and it is in the court in the Buckley case had already started off with the idea in Buckley that independent expenditures are really not tied to corruption, because if I'm making an expenditure and it's independent, then I'm not beholden to anybody. Yes, perhaps there could be a little wink, wink, and nod, nod, but really, if a whole bunch of people are making independent expenditures, then the corruption rationale is not a strong rationale in this context. So I don't think contributions, particular individual contributions, are yet vulnerable as a consequence of Citizens United. The framework of regulation is vulnerable, but not yet to the point of contributions. If contributions, then individual contributions become vulnerable, then there's nothing left, all right, to campaign finance regulation, really, for all intents and purposes.
What about corporate contributions? Do you think they're particularly vulnerable after Citizens United?
Corporate contributions, yes, because they're if Kennedy's point is taken seriously by the court post Citizens United, that there really is no difference between a corporation and an individual. Right, I mean, and he makes that point that we can't draw the line between corporations and individuals. That we can't single out corporations in this political context for different types of regulations, corporations and unions, I should add. If that argument is taken, and that is in the opinion. Now, if it's taken seriously, yes, and I think contributions are going to be very vulnerable. Because the logic then would lead you to believe that that's another line of attack against corporate contributions.
And I know a number of you haven't had First Amendment yet, so just to fill you in on the intuition behind the question, I think it's a good one, is why is it that a modest contribution to a candidate can be prohibited by the government, because that would be corrupting, right? If you give money to a candidate, the candidate may vote the way you want, but having a corporation spend $1 gazillion on TV ads that say, vote for A is wonderful, don't vote for B, B's a communist, right? That's not corrupting, right? Which would the candidate rather have, the modest contribution, right, or the $1 gazillion of TV ads, right? So the idea is that if you take what the court is saying seriously, what exactly is going to be left of the contribution limits? Right? Other questions? Yes.
This is for the whole panel. I know it's a little difficult to speculate based on the limited amount of information we have about Justice Kagan's inclinations, but do you think any of these close cases would have been decided differently if she was sitting in Justice Stevens' seat for these cases?
She might have decided CLS differently. What do you think? She might have decided Citizens United the same way and CLS differently.
Yeah, I mean, I think that the question is illuminating because it's prompted pause and hesitation on the part of the panel, right? Whereas I don't think if it was Roberts, Alito, or Sotomayor, and you asked me that question, you might have gotten the same response. I think there's a lot of uncertainty, right, about what Justice Kagan is going to do in a number of areas, well beyond these. I don't know. I don't know what the former dean of the Harvard Law School, right, who dealt with these policies, and on the one hand, she seems to have the kind of more contemporary, typical liberal commitments, and that stands to reason why this president put her on the court. On the other hand, part of what eased her transition to the court is the number of friends she made, right, at the law school and in politics on the conservative side, right, and really opened up Harvard Law School to conservative views, conservatives that thought that they had been excluded. So I'm not sure what she would have done with Christian legal society. I don't know. It might have been enough to do with what Justice Ginsburg did in her careful opinion, which is says there's a stipulation here,
Yeah.
right? The society's lawyers had stipulated that it's an all-comers policy. That makes it an easier case, right? It's a limited public forum. It's a reasonable and viewpoint-neutral policy. If you're talking about a non-discrimination policy and there isn't a stipulation, that becomes a more difficult case. Any other questions? Yes.
Do you think any parallels can be drawn between the situation in Christian legal society and the current controversies of Duke College Republicans?
I'm not following that.
Could you say more about what the controversies are?
It happened mainly last year, in that one of the chairman, he was expelled from the College Republicans, and he claimed discrimination due to his orientation, but the College Republicans claims it was not due to discrimination, but due to essentially not obeying the statutes of the College Republican.
Right, so there'd be a question of fact.
Sounds like a fact question.
Right, a question of fact about what are the grounds on which he was excluded, and if he was excluded based upon, what, are you saying sexual orientation?
Yes.
Right, if he was excluded based on that grounds, and what's the campus policy? Is it a non-discrimination policy? Is it an all-comers policy?
Yeah, I did look into that a couple days ago, thinking about this presentation, and it is not an all-comers policy. So Duke, to the extent it has any policy, Duke has a very general non-discrimination policy. We don't have a specific one at the law school, except one that applies in the placement context to OCI. So we would, if we had the kind of, this would raise the harder question if it were brought. Now, as it turns out, our Christian legal society is open to everyone. It doesn't seem to follow the national, at least it doesn't follow the local policy of Hastings, if not the national policy. We did look into it. It's very conspicuously open to everyone. So we would never have this case at the law school, but at this law school. But it sounds like a question of fact that's covered by your question presumes that there is a policy that would apply to the College Republicans that was non-discriminatory.
All right, well, I want to thank my colleagues very much and thank all of you for coming today.
Produced by Duke University. Online at duke.edu.